Hello, this is DC Bar's Brief Encounters. I'm Don Resnikoff, the Bar's Antitrust and Consumer Law Committee. And our topic today is proposed legislation before the DC Council, which the DC AG's office described as holding businesses accountable for biases in their automated decision-making algorithms. And job applications are one among several examples of where the law would apply. And we're very fortunate today to have as our guest Laura Moy, who is Associate Professor of Law at the Georgetown University Law Center. She's the Director of the Communications and Technology Law Clinic. And Laura is an advocate for the proposed legislation. As she will explain, she has a professional relationship with an entity that is a proponent of the legislation. And we recognize, of course, that there are those who oppose the legislation, and a number of opponents testified and submitted written statements when the DC Council had a hearing some months ago. But for today, our focus is on Laura's insights, including her response to some points raised by opponents. So I'll say welcome to Laura and ask Laura, would you start by describing your professional role in a little bit more detail? And if you then could follow with some examples of how AI algorithms can be used in a way that harms job applicants and others in analogous situations.
Absolutely. Thank you so much for having me on the podcast. It's good to talk to you, Don, and I'm really happy to be talking about this legislation. So as Don said, my name is Laura. I am on the faculty at Georgetown Law School, and I direct a clinic there. Students in my clinic represent nonprofit organizations and the occasional individual in various policy matters that relate to technology. And one of the things that students in the clinic have been doing is representing the Center on Privacy and Technology, which is a small think tank also based at Georgetown, on matters related to this bill. So more specifically on kind of brainstorming about and conducting advocacy around proposing legislation related to what we're calling algorithmic discrimination in the District of Columbia. And that brings me, I think, to the second part of your question, Don, which is what's the subject matter that we're talking about here? And you teed up this question around algorithms and hiring. I'll back up a little bit and just say we all are familiar with what it's like to apply for a job or for a loan or for housing, and to have our application considered sometimes in competition with other applications. And then we hope that we will be selected on the merits of our application. Increasingly, those decisions are being made on eligibility for those types of things, not just by humans, but by humans and software, sometimes with software or sometimes by software in lieu of human decision makers. And those software tools might be examining our applications for housing, employment, or credit, or educational opportunities, or maybe medical opportunities instead of or in assistance to humans. So we might think that this is a good thing in a lot of ways. This is the advance of technology, making it more efficient to use computers and help us make decisions that take a long time for humans to make. But the problem is that sometimes these software tools could have biases built into them. And we can dig more into some of these examples, but I'll just briefly say that what we're most concerned about and what this bill is all about trying to ferret out, clearly prohibit, and make sure that everyone is on the lookout for, in particular, is when these software tools have discrimination or disparate impact built in. So when software relied upon to make decisions about housing, employment, and credit, or who finds out about those opportunities, when that software does so in a way that disproportionately disadvantages people of certain races or genders or other protected classes.
You gave me some examples when we were speaking beforehand. One of my favorites was the Amazon story, where as a non-expert myself, I get the idea that what the software is trained to do is to understand patterns from the past. so that if the patterns of successful employees included some eccentric characteristic like being good at volleyball, then it might be that the software will recognize that pattern and pick people who are good at volleyball and perhaps men that are good at volleyball. But if you give us an example or two along those lines, I think it would be helpful to the audience.
Yeah, so one of the interesting things about the way that software relied upon to make these types of decisions is developed now is that whereas in the past, you might imagine that if you want to use an automated tool to help evaluate resumes or something like that, you probably have to put together some type of mathematical equation, count if the GPA is on the resume this much, count the number of years of experience in related fields this much, put together a mathematical equation. Now, oftentimes, software that is developed for these eligibility purposes might just be, as you said, kind of trained on historical data using a technology called machine learning. And machine learning is when you basically would give your computer, your software, a bunch of historical data and say, look for patterns in this data that indicate how we have made hiring decisions in the past or how we have evaluated resumes in the past. And then when we give you additional data in the future, try to apply those same patterns and make similar types of decisions in the future. So, as you said, there's this great, very illustrative example of Amazon making an attempt to do this and training its algorithm using many years of hiring data. And what they found out after they did that, likely because the historical data had some biases built in, maybe because human decision makers had some biases built in. But what they found is that the system that they trained using this historical data came out with some preferences that were biased and unfair. So, specifically, it taught itself that male candidates were preferable. It actually was likely to score candidates lower if their resumes included the word women's in them or information about having attended an all women's college. And so, again, that could be because the historical data was biased, but it was trained right into the software system. Now, similarly, there's another account of a hiring algorithm that was being evaluated by another individual, not Amazon's algorithm, but another hiring algorithm, where after an audit of the algorithm, the company that was using it found that the factors that were weighted by that algorithm as being most indicative of job performance was that the candidate's name was Jared and or that the candidate had played high school lacrosse. So again, these are pretty clearly illustrative, I think, of the type of problem that the bill is trying to get at, which is we would like to use some of these software tools to make decision making more efficient, but we have to be really, really careful, especially if they're trained using historical data, that they aren't operating in a way that clearly exhibits bias, and thus, when applied to real candidates for jobs or for loans today, that they aren't downgrading people because of something like their gender or the fact that they did not play a high school sport.
Well, that's actually, I must say, I think a pretty clear explanation. And I'd also say that the idea of software that's trained on historical data that is flawed in one way or another is a fairly straightforward concept to understand, I think. I want to come back a little later to some criticisms of the bill that relate to that point. But before I do that, I want to make sure we get to the sort of the ABCs of what the bill is about. And I'm going to quote from a transmittal letter from the Attorney General to get us started on that point, where the Attorney General said this in his letter. This bill would set baseline standards of fairness by requiring entities that make algorithmic decisions about important life opportunities do, and there's a list of three things. First, stop the discriminatory use of traits like race, sex, and disability in automated decisions, as you just explained, really. And then second, audit the algorithms for discriminatory patterns and report the results and any corrective actions to the Office of the Attorney General. And third, disclose and explain when algorithms negatively affect consumers' opportunities. And then I've left out the part about enforcement and reporting and so forth. But I turn to you to sort of flesh out that brief outline.
Yeah, I mean, I think that that is most of it. I'll just summarize the things that I think it's important to make most clear about what the bill does. One is it clarifies that it is not permissible to have discrimination or disparate impact when making eligibility determinations or deciding who gets information about these important life opportunities, really critical life opportunities, housing, employment, credit, public accommodations, education. And two is that when software in particular, and not all software, but a subset that uses machine learning or artificial intelligence or similar techniques, that when it's being used for these purposes, that one cannot just rest hoping that there is no bias in that tool, but has to actually proactively conduct a study and determine whether or not the disparate impact is occurring. And that's for two reasons that there's this particular focus here on these tools. One is just the greater opacity of decision making when it's made by these types of systems. It's really hard to know as an individual. You're not having a conversation with a human. Humans at a company may not be reviewing the evaluation of every single application. If you submit an application and you just don't hear back or you're denied an opportunity, it's really, really hard to know whether or not the negative decision affecting you was due to some underlying bias in the software. So the burden for conducting that determination really has to fall on the firm itself. The other reason is just that because of the nature of these software tools, they really can make decisions at scale. Maybe a human can review a pile of resumes in one day. A software tool that has, the type of algorithm that this bill is concerned with might be able to evaluate a stack of resumes in the space of seconds. And so the scale of impact is much greater. So again, just plainly prohibit discrimination and disparate impact. And then two is make sure that we're looking under the hood proactively. And then, as you say, there's provisions in there about like providing notice to individuals, about filing reports that these audits have been performed with the Office of the Attorney General. There's enforcement tools, but the really big things are one, prohibit, two, look proactively and make sure it's not occurring.
So when you mention that the process can be quite opaque with use of software, that brings me to a point that critics have made that really you don't need such a statute. Their point is that we already have anti-discrimination laws in the Federal Human Rights Acts from the 60s, the DC's own Human Rights Act from the 70s, and those are very clearly prohibit discrimination of the kind we're talking about. They prohibit it even when there's no intent. So the critics suggest, why is it that we need an additional law focused exactly on these algorithms? You sort of touched on that in your last discussion, but perhaps you could say a little more about that.
Absolutely. I'll make 2 points on this. And one is that even though, yes, arguably the discrimination and disparate impact in these areas already is prohibited under existing DC law, we think that the clarification is necessary because many entities relying on these tools may not realize that. And in fact, they may think that if they are turning from using humans to make decisions to relying on a software tool, that they actually are in the clear with respect to discrimination and disparate impact because computers are colorblind, right? So they might think that, well, this tool is going to be better than humans. We're doing better already. This is, sometimes this process is referred to as math washing, right? Just this idea that computer is going to be objective and unbiased, and it's just not true. So it's really important to clarify that there's a potential problem here. And in fact, we've seen in some of the responses from industry about the bill some indication that there might be questions about, from them at least, from some regulated entities, about whether or not they are liable at present even when they have no discriminatory intent. So the clarification is probably necessary. The second reason, though, is that, as I said, the bill really is about, one, prohibition of discrimination and disparate impact, but two, taking a proactive look under the hood to see whether or not it's occurring before it does. And the reason that that piece is necessary, so that's definitely an add-on from the existing DC Human Rights Act. And that's necessary because without a piece like that, there might actually be something of a legal disincentive for firms using these tools to go look under the hood. And I often point people to this great piece by mathematician Kathy O'Neill that she wrote several years ago. Kathy O'Neill wrote this book called Weapons of Math Destruction, Math, M-A-T-H. And she also now runs a professional algorithmic auditing company. That's what she does as her job. And she wrote this great piece a few years ago. It's called something like Amazon's Gender Biased Algorithm is Not Alone, right? So we talked about this Amazon example. And she said in this piece, essentially, that after the Amazon hiring algorithm got a lot of press coverage, there was concern by other firms, oh, hey, we could potentially have the same problem. And she had a number of follow-up conversations, in particular with engineers and staff at various firms that were interested in determining how they could do an audit of their own to look for bias. But oftentimes, once she started having those conversations, then she eventually got a call with the company's lawyers who essentially said, actually, we've decided not to do this analysis. And that's because they made the reasonable determination of, a risk management determination that if the audit were conducted and they determined that there was in fact bias in an algorithm that they were relying upon for decision making in housing, employment, or credit, then they would be on the hook to fix it. And so rather than incur that type of liability and responsibility, many lawyers were making the very reasonable determination that it's best to just counsel the company not to conduct the audit in the first place. And so we think the legislation is really super important to shift that incentive and ensure that firms are on notice that they have to go look under the hood and determine whether or not the problem's occurring.
Okay, so thank you very much for that. I'm going to turn now, if I can, to another topic, which I know is of great interest to you, is privacy issues. I know that you're a bit of an expert in that area. My own reading of the statute suggests to me that there's really a great deal of concern for the privacy of individuals that would be affected. There's a lot of language about that. On the other hand, I noticed that some of the commenters, particularly this BSA Alliance as an example, complained about privacy issues and said that, and I'm paraphrasing what they said, that the bill's expansive reporting requirements could be read to require companies to disclose large amounts of data, even though those disclosures may inadvertently create significant security and privacy risks. And the bill, the commenter continues, requires entities to retain data for a long period, which can conflict with data minimization requirements and privacy laws. So I wonder if you could comment about the issue of privacy as it relates to this statute.
I would love to. And I think it's helpful to know that for many who are advocating for this bill or for other types of algorithmic accountability or algorithmic anti discrimination legislation, we view this as kind of privacy legislation 2.0, which is to say, what is the point of privacy? If the purpose of privacy is to protect us from the harms that flow from improper uses of our data or from harmful uses of our data, then what could be a bigger harm than discrimination? I mean, there are other bills out there or other policy proposals out there to try to directly address other types of harm that flow from uses of data, right? Harms like misinformation and disinformation or voter suppression, right? Many data-driven harms that are kind of things that we've seen really rearing their heads in the past several years, as kind of like the fruit of our privacy failures over the past several years. Discrimination is one of those, right? The possibility that big data decision making, big data being used to train machine learning algorithms and then deployed in areas like housing, employment, and credit are being deployed in a way that exhibits bias, and that truly is the harm that we need policymakers to address. So we've gotten past the point in time when privacy could be protected, or I should say, when people could be protected from data-driven harms just by giving them control over their data or giving them notice about their data and the opportunity to provide consent or withhold it for their information to be used. Now we may have to look and say, what are the harms? let's directly address them. So, yeah, so just to put a big frame on this, I think I would say that anti discrimination legislation, and particularly algorithmic anti discrimination legislation, is privacy legislation. This is what privacy is all about, is protecting us from harmful uses of our data. So, yeah, and then I guess just like more narrowly about this concern about keeping information for the purpose of conducting the study or collecting information about decision making for the purpose of conducting the study, and how in some ways that goes against data minimization approaches. I think that is true in some respects. That is somewhat unavoidable, that in order to determine whether or not decisions are being made fairly, we have to collect more information about what the decisions are that are being made and how they're being made. And there's just going to be a balancing of equities that needs to take place. Would we rather have less data and not know about the fairness questions, or have more data and know? I think we need to have more data and know. And also, I think that if more data is collected and held, then it should be collected and held in a secure way. But I just think it's unavoidable.
Thank you for addressing that for us. In the time we have left, I'd like to be able to do something more on objection of critics. One I picked out to talk about is represented by a comment in the address to the council by the Safebar law firm. And the gist of it is complaining that there's complexity to the statute, and there's a lack of clarity on such terms as algorithmic process, machine learning, artificial intelligence, and some others. And also so that the scope of the pending bill is unclear. I will say to you, at the risk of revealing my own biases, and I don't like to be critical, but I think the law firm is being lawyer-like in the sense of suggesting complexity where it may not necessarily exist. I mean, the basic principles you explained before about what we're looking for, in a way, fairly straightforward. But this is, I think, a category of criticism I've seen a lot. So I think I'd like you to comment on it.
Yeah, thank you for that. I'm happy to talk about this, and I think that this is actually kind of a great question to take this conversation in, because as the bill moves toward markup, it is really important to make sure that we get the language right, right? And so if there are questions about what it covers or does not cover, I think that those questions should be aired and should get their answers. And I think that to the extent that potentially covered entities have suggestions for how the language could be clarified, those suggestions should be provided to DC Council and the Office of the Attorney General. I'd be happy to talk to folks about that. So I love hearing questions like this. But then let me try to address it a little bit. And I'll start with something that you kind of touched on a little bit here, which is there is going to be a lot of objection in general to legislation that is creating new obligations because it's costly, right? Compliance is going to have real costs for firms that are subject to new areas of regulation. There's no question about that. That said, we think it's really important that the obligations as set forth in this bill do become law, because with great power comes great responsibility. And if software is being relied upon to make decisions in areas that affect people's livelihood, then we have to make sure that those aren't black box decisions. Someone has to look inside the box and make sure that the decisions coming out are fair. So, okay, and now directly on the question of the defined terms in the bill. So machine learning and algorithmic decision making and artificial intelligence are all terms that have been used repeatedly for years in scientific literature and legal literature, as well as by various legislative and other policy bodies. So, machine learning has been defined in a body of literature as kind of, this particular subfield of computer science where, as I described before, software is being used to learn from past experience and past data and improve performance or learn performance over time. And this exists out there. There is this body of literature. These terms in the bill were not pulled out of thin air. And we do think that there's support for them the way that they are. And so there's a report from the European Parliamentary Research Service, and actually my colleague Cynthia Koo at the Center on Privacy and Technology wrote about some of these things in her written statement following the September hearing. So I'm drawing somewhat here from some of the citations that she found and discussed there. But yeah, I mean, the European Parliamentary Research Service has this report defining algorithm and algorithmic decision system, artificial intelligence and machine learning. These terms and others have also been defined in laws from the European Union and legislation introduced in Canada. So like there are globally, there is precedent for this. And then I should also say that there have been bills introduced in Congress here in the US also. So this bill, yes, is calling on entities to make some interpretation of what these terms mean, but there is a broad and global body of literature and community that has been defining these terms for years. And so we think that it is sufficiently clear for entities to know whether or not they are covered. But I'll just circle back to the beginning of my response and say, that said, to the extent that there are suggestions to make the language even clearer, I think that all of those who have been engaged on the bill and are interested in trying to move it forward to make decision making more fair would welcome those suggestions, myself included.
I'm going to take some of what you said just now about availability of information to ask you my wrap up question, which is I hope not impossible, but we'll see. That if you take a group like, let's say, my DC bar communities, consumer law, and let's say for the purpose of discussion, there's a general sense that the goals of the statute are great, but there's a concern that the complexity of the technology is a little overwhelming for a lay group to deal with. How would you advise us to go about our homework to bring ourselves up to speed to be able to make an intelligent suggestion or endorsement of the bill?
Anybody who is interested in the basic gist of the bill, right? Which is we know that discrimination has always existed, and we have been trying to combat discrimination through legislation for decades. This is just where discrimination has moved in the 21st century. So the basic gist of the bill is yes, software, maybe some of the technical details might seem somewhat complex, but the underlying principles are straightforward. And that's that sometimes decision making, especially in these areas affecting important life opportunities, may be made in a way that is not fair and particularly unfair for people in historically disadvantaged communities. And that increasingly, as software tools are used to assist in making those decisions, that those software tools might have the same problems built in. So the bill is somewhat complex. The technical subject matter is complex, but the underlying principle really straightforward. And I think that all of those of us who care about discrimination and combating it can understand that. Now, if folks want to go and look at more materials, the DC Office of the Attorney General, when it introduced the bill in December of 2021, put out a press release on the bill that I thought was very helpful. It really breaks it down, explains what it does, has some useful supportive comments from organizations in the district and national organizations that have been supportive of the legislation. And so that's a good place to start, or to reach out to the Office of the Attorney General or to our clinic at Georgetown or any of the supporting organizations to kind of find out more. And then I'll finally just say that when we had this hearing in September on the bill, which lasted over 7 hours, I should say, when the committee and the DC Council held this hearing and our client testified, and so did one of the staff attorneys in our clinic, there were really a number of organizations that testified, and those included both organizations that are really focused on technology and organizations that are focused more broadly on discrimination. And for organizations that have been working on discrimination, racial justice, and social justice issues for years, they are engaging with this subject matter, and I think can help bridge those gaps for entities that have questions. And so I would take a look at the hearing record from the hearing in September and really just reach out to any of the organizations that are there. I hesitate to name them because there are so many, and I don't just want to like draw on specific organizations and volunteer them to speak about the bill. But again, I'm happy to talk to anybody, and there are a number of organizations and general statements of support for anti-discrimination in the 21st century, I think would be very welcome by advocates of the bill.
I take your point because I did read through that record, and I do see As you say, there were organizations that were focused on the discrimination aspect, not the technical aspect. And so there are a number, more than one or two, that focus on the discrimination issue, the issue of the need for supplemental legislation, and did not go into the technological details, nor would you say they needed to. And so those provide very good models for groups like the ones I described, which I should be careful to say I am not representing at all that that's what my group thinks, but your suggestions along that line are very helpful. But with that, I think we're at the end of our time here. So I think I'll thank you very much for making the time to be with us and to explain some things about this proposed legislation. I think it's been very, very helpful. Thank you very much.
Thank you so much. I really appreciate the opportunity.